Let's take that debate forward. Rajiv Gandhi's killer's release, is it a case fit for a judicial review? Did the release in the first instance set a wrong precedent? Should life term in such cases mean the whole life? Why was the centre silent during the hearings? Aman Lekhi is former Additional Solicitor General who's worked under this government. Colin Gonsalves is Senior Advocate of the Supreme Court. A. Saravanan is DMK spokesperson, and S.G. Surya, State Secretary of the Tamil Nadu BJP, joining us. I want to first get in the politicians to understand the politics playing out. A. Saravanan, you might have just heard Abhishek Manu Singh be very clear. They should not have been released, and yet your Chief Minister, Mr. Stalin, is celebrating it, calling it a historic day.
Yes. Yeah, Rajdeep, it is correct. Our Chief Minister is celebrating it because this is a victory for federalism. The governor of the BJP, the governor sent by the BJP, has been putting spokes on the effective functioning of the state governments. The governors have been spoiling the democracy in the state of Tamil Nadu. He has been sitting on this file for the last 4 years. And that is why the Supreme Court said the governor has enormously delayed this and they have released him.
No, but it's not about the governor. Dr. Singhvi is making the larger point that this is a conspiracy that involved the assassination of a former Prime Minister, affected the integrity and unity of the country. You cannot have individual states for their partisan political ends asking for release.
No. Yeah, Rajdeep, I think I would say that is a very narrow view. It is presumptive. It's very presumptive. It presumes that the state government does not have any role to play on the national security or national sovereignty. I think Mr. Singhvi will accept to this.
But what was, let's be honest, do you really believe that people who are deeply involved in the conspiracy should be let off?
Yes, I'm coming to that, Rajdeep. See, this is not without precedent. This is not the first time this has happened. Our father of the nation, Mahatma Gandhi, was killed by an assassin, by a conspiracy. The conspirator, Gopal Vinayak Godse, was released by remission after spending 20 years in prison. If that can happen to Mahatma Gandhi, we are asking on a humanitarian ground. There is nothing more to it, no politics to it. The reason we have sought for the release of these killers is that they have stayed at death row for 10 years, for 10 long years. Tell me who in the country has stayed at death row? What more torture can you inflict upon them? And they have spent 30 years. This is purely based on humanitarian grounds. And Mr. Rahul Gandhi, I want to put it on record, Mr. Rahul Gandhi has said he has forgiven. He has forgiven all of them who were involved. This apart, if I am, let me come to it, Rajdeep. If I am a congressman, if my leader was killed the same way, I would feel the same anguish. That apart, we have legal system, we have precedents for what has happened, we have Article 161. So they are saying make Article 161 redundant by just this one magic word, national security, state sovereignty. It is not acceptable in a federal setup.
Okay, you made your point, Mr. Saravanan, very strongly. S.G. Surya, State Secretary, Tamil Nadu BJP, do you agree with what the centre now is doing, asking for a review?
Can I respond to points made by Mr. Abhishek Manu Singhvi? He said there is a lukewarm response from the central government in dealing with the case. Going back to the history, in 2001, after their conviction, these people who are released now, they applied for the mercy petition. And the decision on the mercy petition was taken in the year 2011. So the very reason for the remission of death sentence to life sentence is because of the inordinate delay by the President and the central government which were in power during the time, which means directly the UPA. So my question is, why did it take so long for the UPA government to delay the decision in rejecting the mercy petition when their president was installed in this country? Secondly, the death sentence was commuted to life sentence on February 2014 when the UPA government was still in place. The very moment the death sentence becomes life sentence, it became very clear that they will be released one day because they were not convicted for terrorism charges, but they were convicted only on under 302 for murder. So it was very clear. So my question is...
So why is the BJP now seeking a review then?
No. BJP is not seeking the review. Rajiv, Centre is seeking the review because the Centre says they were not a party to it when the remission decision was taken by the Supreme Court. The central government feels that it should be a party because it should not set a wrong
So
precedent when foreign nationals.
you're suggesting that this review is only procedural. Let me get the legal points of view for a moment. First, you, Aman Lekhi, do you agree with what the centre has done? Was there an inevitability, given the fact that according to some it sets a very dangerous precedent that the centre is not even a party to a case like this?
No, I find the ground taken by the centre absolutely incomprehensible. Ravi Chandran follows the order in Pirarivaran, and the government of India was the party in that particular case. That order was rendered in May, and despite being rendered in May and that being the basis of the subsequent order, inexplicably there's been no review which has been filed against that order. The review has been filed only now, firstly. Secondly, it's manifestly wrong. The first order of the Supreme Court is manifestly wrong because first, I have a reservation that the governor could at all have entertained it, but presuming the governor could have actually entertained it, there are three things which are absolutely incorrect in this particular order. The first is that the Supreme Court could not have decided. This is, as far as commuting is concerned, the executive power. Neither the judiciary or the legislature got any role to play in it. So there was no occasion for the judiciary to intervene for the purposes of commuting the sentence or releasing the people, because this is extraneous. This is something which is constitutionally forbidden, firstly, and this stares us in the face. Secondly, the court referred the period of detention to say they've already spent 30 years in prison. Because they spent 30 years in prison, therefore we are entitled to release. Now, this is not a question of bail. Because it's not a question of bail, the period of detention is relevant because the sentence is life, and life means normal life of a person. So even if it's 40 years, that's no ground at all for the purposes of releasing. And thirdly, most importantly, the circumstances they refer to is the conduct in jail. The conduct in jail is, in my opinion, irrelevant because the act in question was one of complete depravity, and correctly, which was mentioned by the Congress, entailed the assassination of the Prime Minister involving elements who are not Indian nationals, and the very gravity of the crime mandated that as far as those who have committed it should remain in custody.
So you're saying life should have been life in a case given the nature of the crime committed. Colin Gonsalves, how do you respond? As someone, you've always been against the death sentence. Do you believe life could have been life in a case like this?
Well, I think we missed the point in the debate completely. Just a few months ago, in Payas' case, everything that was argued on your program today was argued before the Supreme Court. This was a terrorist offense. This was an attack on the Indian nation. Therefore, the central government, if it were a terrorist offense, the central government would certainly have a right to poke its nose in the matter. But the Supreme Court in Payas' case said, looking at the judgment in Nalini's case, looking at the judgment that was delivered many years ago, noticed that all these persons were acquitted of the terrorism charge under UAPA. So there was no terrorism charge left. There was no so-called attack on the nation to be discussed. All that remained is the murder of a person, 302. And in a 302 case, unlike a terrorism case where the central government can say, I want to be heard, in a simple murder case, 302 case, the central government has no role to play, said the Supreme Court a few months ago. And so today, you can't repeat the same argument because we have a 3-judge bench of the Supreme Court in Payas' case saying the jurisdiction will lie exclusively with the state government. And I applaud the state government for fighting against a very cruel stand that all these gentlemen are taking to keep people in jail after 32 years of imprisonment. Cruelty, extreme cruelty. And I applaud them for taking this stand. And I want to end by saying the central government will learn a lesson. The people of Tamil Nadu will not treat this as a simple murder case or anything like that. They will take this as a matter of Tamil pride, and it will be a major political issue in the years to come and in the elections. And the central government will learn that by pushing ahead with this cruel stand, they will be taught a lesson in the elections.
Yeah, but I could turn around, Colin Gonsalves, and say, if you remember a few months ago when Bilkis Banu's rapists and murderers were released after spending 15 years in jail, there were those who said, you need life is life. So, you know, we need clarity on what is the basis when you are going to remit a sentence. This is a conspiracy to assassinate the Prime Minister of the country.
Not Prime Minister, former Prime Minister, and the Supreme Court made a very important distinction. As far as the Supreme Court was concerned, they said a former Prime Minister is like any citizen of the country. No more, no less.
Aman Lekhi, you want to respond?
Yes, yes.
Aman Lekhi, you want to respond to that?
Yes, I do.
Yes.
I mean, with all due respect, Mr. Colin Gonsalves is wrong. It's not that simple. As far as 302 is concerned, the argument is because it's not Tata, therefore Centre has got no role. Because 302, the state, this is a misreading of Sriharan. The judgment that has been rendered in Perarivaran interprets Sriharan in a manner which is incorrect. In the case at hand, notwithstanding 302, ideally it should have been the central government, considering the circumstances of the case, more so because in so far as the power under 161 is concerned, has been read at 435 of the Code of Criminal Procedure, because this matter was investigated by an agency which is a central agency, and therefore presuming the state government has got a power, the state government doesn't have exclusive power. The state government has to act along with the central government, conceding that the state government has the authority.
Yes, but Mr. Lekhi, for 6 months, the centre did not act. The fact is, if the centre did not act for 6 months, you can't suddenly wake up one day and say, oh, we are reviewing the judgment.
Absolutely correct. What the centre has done is not correct at all. As at the outset itself, the order was passed in May. The order on which the subsequent order is passed in May, inexplicably, despite the fact the Government of India was participating in those hearings, was represented to the Solicitor General and Additional Solicitor General. Notwithstanding the order, there was no review filed of that order, and only a subsequent order which is premised on the previous order review is filed, and that too belatedly. As for the conduct the Government of India is concerned, the conduct the Government of India and so far the bona fides is concerned and sincerity in filing a review is in clear doubt. And the government which is being made in a review application, that they were not a party, in my opinion, is complete hogwash.
Okay.
Because the Government of India has been a party into these proceedings from the year 2014 and is specifically a party in the Perarivaran case. So the government cannot possibly say it did not know. In any case, it's a public domain. And the government could have in any ways intervened, presuming it did not know, which I don't buy.
But, you know, let's be also clear. And I think, Colin, you can, before I come to the politicians, you know, just give clarity on that. Across the world, the global trend in jurisprudence is now for reducing the maximum period in detention, often to a single-digit figure. US and UK academic trends favoring a maximum of around 7 years, often 9 years. Do you believe, therefore, that this sets a precedent? God forbid something like this happens tomorrow. Do you believe that every case should be seen differently, or is this to be a precedent for the future? I am involved in a conspiracy to assassinate the former Prime Minister, and I get a very definite finite period in jail.
Well, it's as simple as this. If it was a murder case, as the Supreme Court held many years ago, Justice K.T. Thomas's judgment, if it was a murder case, they would get out 14 years minimum, and after that the state government can act and remit the sentence. Now, as compared to 14 years, which was a possibility in this case, you have 33 years, which is total barbarism for any democratic
So what according to you would be a maximum punishment? That according to you fits the crime?
If you take parts of Europe, for the most heinous crime, terrorist crimes, like bombs, blowing up trains and so on, it would be approximately 25 years would be the limit. And I think India must look at its reviewing and sentencing policy, because it's a very hard point of view. It's a very cruel point of view to keep a human being in jail for 33 years. And in Perarivalan's case, he was put in when he was 19. He was a college student and he was making batteries for a science class. And they came and grabbed those batteries and said, this is the battery that you use for the bomb. And he was in a cinema hall, for God's sake, when they came and arrested him. 19 years, a young man at 19, and now he's 33 years have passed. Cruelty, unmitigated cruelty.
You're calling it unmitigated cruelty.
I applaud the Tamil Nadu government for the courage in saying they must be released.
Aman Lekhi, is it unmitigated cruelty to put someone in jail for 33 years?
Absolutely not. In fact, then you have to actually undo the IPC, ignore the provision of the IPC. We define life. Life is the natural tenure of one person's foray on earth. If you call the life imprisonment in that way, then the Supreme Court has actually upheld life imprisonment. Life imprisonment is life. Remission is not a matter of right. It goes to discretion, and discretion is not something which should be exercised in a matter like this. So the question of it being barbaric doesn't disregard the provisions of the law and ignores the fact that the sentence which has been of life is one which is warranted in law. As long as warranted in law and the law stands, merely a description, it's barbaric for 35 years will not stand.
Okay, can I get you, Mr. Saravanan? What will the role that the Tamil Nadu government will presumably implead if the Supreme Court chooses to review this case? That you all will implead and maintain your stand in the court?
Yeah, no, see, whatever we have stated earlier, our stand stays firm. We are not going to prevaricate because we have been asking for this release for so long. See, in 2015, the Constitution Bench of the Supreme Court has clearly stated that there are no charges under terrorism of the Tara Act. They have been convicted simpliciter 302. So only the state government has the authority to release them or not to release them. And that authority has been exercised. Now, look at the way the BJP is acting. When it is coming to Gujarat Bilkis Banu's case, immediately the union government says, yes, okay, release them, no problem. Rape, murder, no problem at all. 15 years only, release them. But here, the governor sent by the BJP wantonly for political gains, for political gimmickry, held on to those files for 4 years. They blew a death knell to state autonomy, to federal structure for constitution. If there is one thing BJP is very adept, that is using the office of the governor. That is what they did here.
Can I get a final word therefore from my BJP guest, Mr. Saran? You want to respond one final time to what you are hearing from the DMK? They are saying that now suddenly you've woken up and you called for a review of this particular case. What were you all doing all these months?
No. See, in the May when Payas was released, he was felicitated by the Chief Minister with a shawl and he was hugged. I think it is a wrong precedent for any chief minister to send out to this country that you can kill the former prime minister and come and hug the chief minister. So again today you have problem when there is another life convict who goes to the Supreme Court and says they had killed 15 people, I killed only one person, so you please release me also on the same grounds. So we are worried with whatever is happening. So I think the review petition should give answers to all these questions.
No, but is the Tamil Nadu BJP very clear that they want these convicts to go back in jail? Are you clear about that?
It all depends on the Supreme Court, Rajdeep.
They don't have
we do not have a stand. At the end of the day, when the Supreme Court says we have nothing to say, our stand doesn't matter in front of the Supreme Court. So that
so you will wait to see what the court does. Yes, Mr. Saravanan, a final word.
Yeah. See, this is about Mr. Payas. This is what Mr. Gonsalves was talking about. Unmitigated disaster. The investigating officer with regard to Mr. Payas went on record, filed an affidavit in the Supreme Court, stated that he wantonly, intentionally recorded the statement wrongly so that Payas would be convicted. So that is why Payas is different from all others. So let us not mix all of them and paint everybody with the same brush. But of course, the Supreme Court did not consider that was one of the reasons for the early release of Mr. Payas.
Okay, let me leave it there.
Yeah.
It is a complex case. It is a case which of course shocked the nation and at the time itself and beyond. But at the same time, it raises several questions of jurisprudence. Should life be life? Should it be commuted? What are the conditions under which commutation should take place? Is it cruelty to keep someone in jail for 30 years or more, or is the gravity of the crime such that you cannot allow people to be let off? Lots of questions which hopefully will be answered by the Supreme Court in the Rajiv Gandhi assassination case. To my guests, thank you so much for joining me here on the news today.